This lesson will cover Chapter 15 on the Judiciary. First, let's cover some basics. Who makes up the federal court system? We have lower courts, we have appellate courts, and we also have the Supreme Court to look at. All of these judges are appointed by the President with the approval of Senate. Although we recognize that presidents prefer judges that are more favorable to the policies they stand by, we know that judges also enjoy a certain level of judicial independence. What this means is that judges are insulated from the need to feel accountable to voters or folks who would elect them. They're not elected, so they don't have as much pressure from public opinion. This means that they can make impartial decisions that are based on law. This judicial independence can be maintained because judges serve life terms, and they shall hold their offices during good behavior. In addition, their compensation is not diminished during their time in office, and this can be said to maintain their judicial independence because it means they do not have to adhere to the expectations, the desires, or the pressure of a boss, or so to speak. Even though judges don't have formal qualifications, there are expectations as to what kind of qualifications they should hold. They should be competent, meaning they should have law degrees, and this can be demonstrated in the fact that 2/3 of nominees are sitting judges. But some other things that presidents may look for when they choose nominees would be education, where an individual went to school. Typically, judges come from Ivy League schools where they get their law degrees. They have experience, again, as practicing lawyers. In addition to that, have been judges themselves. They're professional. They also demonstrate personal integrity, and they're able to provide sufficient written and oral communication skills. Some presidents may value representation as an important qualification for judges. Presidents may believe that judges should demographically look like the proportional demographic breakdown of the country. They may also believe that that kind of representation can lead to a level of understanding, looking out for those groups when it comes to the way that their rulings may potentially affect those groups. And in addition to that, it's symbolic representation. When there is diversity among government officials, that can demonstrate that democracy is functioning because the individuals that are serving the citizens also look like those citizens demographically. Our courts run on an adversarial judicial system. This means two parties legally dispute each other, and the court has to determine which side wins. The term jurisdiction determines the legal authority of a court to handle a case. As you've learned about as early as elementary school, the judicial branch, or the courts, interpret the law. When interpreting the law, there are a variety of sources of law that the courts may look at. First, we can look to the Constitution. Then we can look to pieces of legislation that might be passed by Congress. We can look to executive sources that create different types of law. So when the executive agencies or departments have to fill in the gaps that bills may not cover, those laws are also up to the interpretation of the courts, all of which must comply with the U.S. Constitution. One of the most important concepts under the judiciary is the concept of precedent, and all of these terms are associated with precedent: common law, the doctrine of stare decisis, and precedent cases. Common laws may not be written laws. Instead, they are grounded in tradition and previous judicial decisions. So, depending on what those decisions were previously in previous cases, that would dictate how the law should be interpreted. The doctrine of stare decisis aligns with common law. It means let the decision stand. And this means that judges are apt to identify previously decided cases with similar facts and apply them to current cases to determine what would be constitutional. Cases that would be used within that doctrine are known as precedent cases. When judges make their rulings, they will apply legal principles that are used in precedent cases to decide the legal dispute they're currently resolving. When arguments are presented to judges, these cases are often brought up to validate the arguments in the case. Judges interpret the Constitution when they look to make rulings on cases as well. And so if we look at cases dealing with civil rights, civil liberties, even when we're looking at the reluctancy for the courts to challenge laws that are passed by Congress, we know that the supreme law of the land is the Constitution. That means the courts are more inclined to see that national laws can't violate the Constitution, treaties can't violate the Constitution, the Supremacy Clause trumps state laws, and even with regard to the bureaucracy and the policies that might be passed within those agencies, there also is a reluctancy to strike down those laws. One example would be with Abergavel versus Hodges. And in this case, the Supreme Court interpreted the U.S. Constitution to guarantee the right to same-sex couples to marry throughout the United States, and state governments could no longer ban same-sex marriage. The court will also look to legislative statutes or laws. So we can look at U.S. codes, which are a compilation of laws passed by the U.S. Congress, and penal codes, which are a compilation of state criminal laws. Executive orders are subject to judicial review. This means that the courts can deem an executive order unconstitutional. In addition to that, there are also other checks to include the Congress deciding whether or not to fund said executive orders, and so that can be a major limitation to the efficiency of that executive order. There isn't funding that backs the enforcement. There are different types of lawsuits. Trial courts resolve disputes over facts and cases. They can involve defendants who may be harmed by society by violating criminal laws or who caused harm to individuals. It can also include an organization violating civil law. Verdicts in criminal trials and civil trials may be appealed for review to correct errors over the trial. Criminal trials are different from civil trials in that they deal with conduct that's harmful to society and is prohibited by statute. It's also prosecuted and punished by the government. So in this case, the prosecution would be the government. In civil trials, you're typically looking at two parties involved in making oral arguments to the court. The concept of beyond a reasonable doubt is the standard of proof the government must meet in criminal cases. The government must convince the judge or the jury that there is no reasonable doubt that the defendant committed the crime. This can bring us to certain liberties that are enjoyed in the Bill of Rights. This includes the right to a speedy trial, no self-incrimination, the right to an attorney, protection from cruel and unusual punishment, and no double jeopardy. There is a difference between trials held in district courts and the Court of Appeals. So, some terms to keep in mind: a jury trial is a trial in which a group of people are selected to hear the evidence presented and they decide on guilt or liability. In a bench trial, that's a trial which the judge who presides over the trial decides on guilt or liability. There is no jury. So if a case is ruled upon and guilt is determined, there is an option for the defendant to appeal that decision in an appellate court. So appellate courts look to panels to review paperwork, oral arguments, conversations, and written announcements, public opinions, and legal rationale. And so they may be able to overturn the previous court ruling that happened at the district level. And on a side note, in federal trials and most state trials, all jurors must agree to a ruling unanimously. Let's talk about the structure of federal courts. There are 3 tiers in the hierarchical system. The first tier includes U.S. district courts. There are 94 of them in the United States. This is where a court would hear a case for the first time. These district courts have original jurisdiction. The next tier would be the U.S. Court of Appeals, and there are far fewer of those in the United States because not every case is going to have the opportunity to get appealed. So there are 13 in the U.S., and they have appellate jurisdiction. This means that they can hear a case that has already been decided upon in a lower court, and they can potentially reverse that decision. The top tier is the U.S. Supreme Court, and they also hear appellate cases. And so it's very possible that a decision would have been made in a district court, another decision would have upheld that in the Court of Appeals, and then the Supreme Court would take it up and still potentially reverse that decision. There are also rare cases where the Supreme Court has original jurisdiction, so this may have to do with lawsuits involving ambassadors or foreign dignitaries, or could involve different states or multiple states. There are some unique specialized courts that don't fit into that structure, including U.S. bankruptcy courts, military courts, and tax courts. Looking at the last resort court, the Supreme Court, we can look at it as being made up of a group of judges that evaluate a case together and decide on the outcome. They decide what cases to hear, they resolve the heard cases, and they develop the legal reasoning to persuade the public. It is very difficult for a case to get to the Supreme Court. So of the around 10,000 cases that are petitioned, only about 80 are taken up by the Supreme Court. A writ of certiorari is a higher court's order to a lower court to make available the records of the past case so that the higher court can review the case. In this case, we look to the rule of 4, and this is the practice where the Supreme Court justices determine if they will hear the case. They need 4 or more justices to agree to hear it. Both parties involved in the case will submit their briefs and present oral arguments. Those oral arguments are pretty brief, and they only last about 30 minutes apiece. In addition to those legal briefs that are presented by each party involved, amicus curiae briefs can also be submitted. And in this case, we're talking about legal briefs that are filed by individuals or special interest groups that may not be a party but have a vested interest in the outcome of the case. Justices are already pre-prepared for these arguments because they have their clerks prepare bench memos, and these bench memos summarize the case and outline relevant facts and issues presented in the case documents and legal briefs. There are several models that can dictate the way judges might rule on a case. So the legal model confines judges to laws or existing precedents. The attitudinal model may confine judges to their own ideology or policy stances, and the strategic model may be the consideration of whether the court actually has the jurisdiction or authority to make a decision on the case. When the justices conclude on a ruling at the Supreme Court level, they will issue opinions that hold them accountable to the public. So in these opinions, they have to make constitutional arguments justifying where they stood. So the majority will present their arguments in a majority opinion. The concurring opinion also ruled alongside the majority, but for different reasons, and they want to be able to disclose that. And the dissenting opinion disagrees with how the majority ruled and what the official ruling of the case was, but they want to include their constitutional justification. The very last concept we'll talk about is judicial philosophy. And that's the difference between judicial activism and judicial restraint. Looking at judicial activism, this is an approach to judicial decision-making whereby judges are willing to strike down laws made by elected officials, as well as step away from precedents and create new ones. Judicial restraint, on the other hand, is an approach to judicial decision-making whereby judges defer to the democratically elected branches of government unless their actions clearly violate the Constitution. Judicial activism assumes that society is always progressing and changing. Therefore, the original intent of the Constitution cannot always be looked to or adhered to when making decisions. Judicial restraint would mean that judges would be more hesitant to make decisions that go against laws that have been passed by the branches or the Constitution.